Hi, I'm Hans Holmen, Executive Director of the Collar Institute of Private Equity at London Business School. We're here at our symposium. We've just had an interesting panel discussion on private equity regulation, and I'm here with Laura Cox, who's a partner at PwC Legal. Laura, just a couple of questions, if I may. Firstly, why regulate the asset class? What's the rationale for all this additional regulation at the moment?
I think there's two reasons that are generally put forward for regulation. The first is concern about financial stability and systemic risk. So the question is raised, does PE pose the kind of problem for our economies that, for example, banks do? And if so, should they be regulated in the way that we regulate banks? PE has lots of good arguments why systemic risk is not a problem for them, but still they've got to make that argument and differentiate themselves from the banks and really explain their story about systemic risk and how their type of investment profile differs from traditional bank lending.
Absolutely.
The other aspect is investor protection. So I think that kind of gets lost in the mix a little bit, but it's getting more and more attention. If you think about the MiFID review that's currently being consulted on in Europe, we're seeing much more strenuous proposals about investor protection than we've seen in the past, and thinking about things like whether even professional investors can really protect themselves adequately without more regulation. So you've got two really significant drivers there that are pushing more regulation in the direction of PE houses.
There's certainly a lot to report in the press about upcoming regulation. What does the industry actually fear the most?
I think what they fear the most is having to deal with multiple regulation at once and inappropriate regulation. So a lot of what's coming through is coming through without much consultation. It's coming through in a volume and timing that is challenging for firms given their levels of resource. It's also coming from different directions. So you've got PE fund managers in Europe, for example, having to deal with both European regulation and the implications of regulation like Dodd-Frank and possibly having to register with the SEC as investment advisors. And those types of regulation, despite being driven by the wider G20 agenda, haven't really been conformed in any way. So although they may touch on the same parts of the business, the requirements that firms are having to meet are quite different. For example, in the way that they structure their reporting or structure their compliance function or their risk management function. And they're having to get used to multiple regulators. Mm-hmm. Not only do you have the FSA splitting into two regulators in the UK, but you'll have the SEC as a regulator for a lot of PE firms, and they'll have regular SEC examinations once they register. And you also have the development of European regulators, and in fact more power being concentrated in the European Securities and Markets Authority. I think that's a trend we're going to continue to see over time, where more and more policy decisions are taken either by the EU Commission or by the regulators in ESMA.
Well, it sounds like the asset class has a lot of work to do ahead to comply with these additional regulations. Thank you very much, Laura. I appreciate your time.
My pleasure. Thank you.